become a governor and nominate an unelected governor. Sorry, I'll take that again. For this reason, we find that it is not far-fetched that an elected deputy governor can become a governor and nominate an elected deputy governor who may eventually assume the office of the governor and nominate an unelected deputy governor. For instance, had Honkananu, who was not elected, been vetted and approved when her name was submitted to the county assembly in January 2020, she would have assumed the office of governor upon impeachment of Sonko and gone ahead to appoint an unelected deputy governor. This would mean that the Nairobi City County would have been governed by an unelected leadership. In our scheme of things, such a situation cannot be said to be a violation of political rights under Article 38 of the Constitution. It is our considered view that upon nominating Honkananu and after the County Assembly received the nomination, Sonko's role in regard to the process ended, and that were it not for the court order in the Agoro case, the process would long have been concluded. The impeachment of Sonko cannot have the draconian effect of undoing or terminating the process that was ongoing. We therefore find no error in the action of the County Assembly to conclude the process of vetting after the impeachment of Sonko and the subsequent withdrawal of the Agoro case. Turning to the issue of public participation in the appointment of Honkananu, Sonko took the position that Honkananu's appointment was devoid of public participation, thereby violating Section 6, Subsection 2 of the Public Appointments County Assemblies Approval Act, Articles 10, 23 of the Constitution. He specifically averred that the public was not given 7 days notice of the impending vetting, and neither was the vetting advertised in a daily newspaper with national circulation, nor was the vetting done publicly. The 10th interested party's case was that Honkananu was not vetted at all, but added that no public participation was carried out prior to the vetting. In response, Honkananu submitted that the public was invited to submit their views on her suitability through advertisements in the local dailies. She contended that the fact that the members of the County Assembly, whom I'll refer to as MCAs, vetted her, was in itself a form of public participation. We considered Article 10, Article 174, and Article 196 of the Constitution, Sections 87 of the County Governments Act and the provisions. We also considered the importance of public participation as was considered in the case of Doctors for Life International, among other cases that you'll have an opportunity to look at when you get the judgment. We have considered the evidence provided by the parties hearing and note that on 8 January 2021, the Nairobi City County Assembly placed an advertisement in the Daily Nation newspaper informing residents of the impending vetting of Honkananu scheduled for 15th January 2021. We have given the extract of the advert in this judgment. We do find that through the advertisement, the County Assembly provided clear information regarding the impending vetting of Honkananu. Members of the public were given information on how and where to submit their views, contrary to the assertion by Sonko that the notice did not meet the requirement of Section 7, Subsection 5 of the Public Appointments County Assemblies Approval Act, that the Select Committee on Appointment gives the public 7 days notice before vetting. This requirement was indeed fulfilled. In seeking to find out whether the need for public participation was met, the court has to look at the circumstances of each particular case. Public participation is both qualitative and quantitative. The circumstances of this case are that the nomination of Honkananu was done in January 2020, and the public was all along aware of her impending vetting, which had unfortunately stalled as a result of the orders issued in the Agoro case. Upon the lifting of the restraining orders, the County Assembly once again notified members of the public that the nominee would be vetted on 15th January 2021. There is uncontroverted evidence placed before this court by Hon Kananu through her replying affidavit sworn on 22nd January 2021 to the effect that she appeared before the Select Committee on Appointments on 15th January 2021. The County Assembly order paper for the same day had one of its orders of business as a motion to adopt the report of the Select Committee on Appointments of the vetting for the position of Deputy Governor. It is therefore our finding that the requirement for public participation was met. So I will turn to consider the import of Section 32D of the County Governments Amendment Act 2020 and the Public Appointments County Assemblies Approval Act on the appointment of Hon Kananu. The first petitioner submitted that Section 32D of the County Governments Amendment Act 2020 was not complied with, as there was no substantive governor in office to appoint Hon Kananu after the conclusion of her vetting by the County Assembly. It was his contention that the stated provision vests the power to appoint the Deputy Governor upon the Governor. The 8th and 9th petitioner submitted that Section 32D of the Act is applicable to the process of vetting and appointing as it was done after the Act was enacted on 9th July 2020 and came into force on 27th July 2020 when the office of the Deputy Governor was vacant. According to the two petitioners, the cited provisions as read with Section 4 of the Public Appointments Act required that upon the vetting of Hon Kananu by County Assembly, there was need for a governor to complete the process by way of a formal appointment into office, and that such appointment should be in writing under the county seal. It was the petitioner's position that the crucial step of appointment was bypassed as Hon Kananu was not formally appointed after the vetting process, since there was no sitting governor to appoint her. The 10th petitioner echoed the submissions of the other petitioners that the process of vetting and appointing of Hon Kananu was an illegality for failure to comply with Section 32D of the Act. Hon Sonko joined hands with the petitioners and contended that there is no way Hon Kananu's appointment could have crystallized legally without a sitting substantive governor appointing her, because an acting governor cannot execute such a mandate. Hon Kananu was not averse to the suggestion by the petitioners that Section 32D applied to her appointment, but argued that it applied from the time of the Act coming into force. She additionally argued that by dint of Section 32D, subsection 3 of the Act, she was deemed to have been appointed as Deputy Governor upon the lapse of 14 days from the date of her approval by the County Assembly. On his part, the third respondent argued that Section 32D of the County Governments Amendment Act 2020 should not be applied to the nomination of Hon Kananu, which happened on February 2020 prior to its enactment in July 2020. We have reproduced the provisions of Section 32D of the Act in this judgment. We have also reproduced Section 4 of the Public Appointments County Assemblies Approval Act. And we note that prior to the enactment of Section 32D, the Supreme Court gave guidance in the County Assembly of Embu case on the procedure to be followed in the appointment of a person to fill the vacancy in the office of Deputy Governor. We have highlighted the relevant portion of that decision in this judgment. In the said judgment or opinion, or the advisory opinion, the court went ahead and held that after approval by the County Assembly, the only remaining step was for the Deputy Governor to take an oath of office. Section 32D appears to have adopted the opinion of the Supreme Court in the advisory opinion. A reading of that section clearly shows that a governor can only appoint a deputy governor with the approval of the county assembly. Our reading of the provision does not support the suggestion by the petitioners that there has to be a formal appointment once the county assembly approves the nomination. The petitioners have, however, referred to the Public Appointment County Assembly's Approval Act, which at Section 4 requires the approval of the County Assembly for any appointment made under the Constitution or any other law. Section 11 of the same Act, we have highlighted the provisions of Section 11 of the same Act in this judgment. Under the said Section 11, the appointing authority is required to make a formal appointment upon receiving approval of the County Assembly. There was the Speaker of the County Assembly who was then acting as the governor. It does not follow that where a County Assembly approves a nominee for the position of Deputy Governor and the specific governor who made the nomination is unable to complete the appointment process. Sorry, I'll take that again. It does not follow that where the County Assembly approves a nominee for the position of governor and the specific governor who made the nomination is unable to complete the appointment, then the entire process is rendered a nullity. In our view, whoever comes in to replace the governor who made the nomination can complete the process by appointing the approved deputy governor. We also observe that as at 9th March 2018, when the Supreme Court made its advisory opinion, the Public Appointment County Assembly's Approval Act 2017 had come into force 1 year earlier on 29th March 2017. According to the advisory, once a deputy governor is nominated and subsequently approved by the County Assembly, the only remaining step is the swearing in of the nominee, and this is what happened in the present case. It is undisputed that Hon Kananu took oath of office of deputy governor in compliance with Article 74 of the Constitution and Section 30, subsection 1 of the County Governments Act. It is also important to appreciate that we are dealing with an appointment that straddled two legal regimes, having been initiated under the parameters of the Supreme Court's advisory and concluded under Section 32D of the County Governments Amendment Act 2020. There was therefore nothing wrong with the conclusion of the appointment process under the law that was operational at the commencement of the process. We therefore find no merit in the suggestion that there ought to have been a formal appointment of Hon Kananu after her approval by the County Assembly. And turning to the powers of the Speaker of the County Assembly under Article 182 of the Constitution, on this issue, on the issue of whether the Speaker, while acting as a governor, can appoint a deputy governor whose nomination was ongoing when the governor is impeached, the first petitioner made reference to Article 146, Sub-Article 2 of the Constitution and submitted that the Speaker of the National Assembly, while acting as the President, pursuant to the provisions of that article, cannot reconstitute the national government or otherwise exercise the powers of an elected president. He urged the court to draw parallels from the said provision and find that a Speaker of a county assembly acting as a governor pursuant to the provisions of Article 182, Sub-Article 5 of the Constitution cannot exercise the powers of an elected governor. According to the first petitioner, the Constitution does not contemplate a situation where the Speaker, while acting as a governor, can relinquish the office to any other person apart from the elected governor. On their part, the 8th and 9th petitioner submitted that the Speaker, while acting as a governor, has no powers to appoint a deputy governor. They contended that the office of a deputy governor is an elective office which draws its authority and legitimacy directly from the people, as opposed to the Speaker who is elected by members of the County Assembly, and it would be a constitutional absurdity for the Speaker to appoint a deputy governor. The 10th petitioner joined issue with the other petitioners and argued that the Speaker cannot appoint a deputy governor as the position is elective, not appointive. We find that the submission by the first petitioner that Article 146 denies the Speaker of the National Assembly, while acting as President, powers to reconstitute the national government or otherwise exercise the powers of an elected government, not to be supported by that provision. We will let the article speak for itself, and we have placed it here in the judgment. We, however, note that Article 134 of the Constitution, which we have also highlighted, the stipulations, alongside Article 147. So from the cited provisions, we note that they are applicable to a situation where the President is temporarily absent or incapacitated, or where he or she decides that the deputy should act. This scenario is not permanent, as the President is expected to come back to office and cannot be equated to a situation where the Speaker of the National Assembly is acting as the President for a period of 60 days pending the holding of the presidential election. We find no useful insights which can be of help to the petitioner's argument. So I'll take that again. We find that no useful insights which can be of help to the petitioner's argument can be gleaned from the above scenario. The first petitioner relied on Section 32, subsection 4 of the County Governments Act 2012 to support his argument that the Speaker, while acting as a governor, cannot exercise the full powers of the office of governor. We have highlighted that provision here, and also Article 179, sub-Article 5 of the Constitution, which provides as follows: when the county governor is absent, the deputy county governor shall act as the county governor. The cited constitutional and statutory provisions are similar to Articles 134 and 147, sub-Article 3 of the Constitution, which we have already discussed above. They apply to a situation where the governor is temporarily absent from office and cannot be equated to a situation where the governor has permanently left office. The petitioner's argument is essentially that a Speaker of the County Assembly, while acting as a governor, has limited authority in performing the functions of that office. Their argument is that one of the limitations is that he cannot appoint a deputy governor. Under normal circumstances, this argument is correct, in the sense that the Speaker is holding the office as he awaits the election of the governor within 60 days. In the present case, however, we are not dealing with a perfect case scenario. Had Onkananu been vetted and approved or disapproved upon nomination, the current predicament would not have arisen. In that case, should have been a deputy governor before the impeachment, or in the alternative, Sonko would have nominated someone else. Taking into consideration all the prevailing circumstances, the pending process of vetting of Onkananu cannot be wished away. The process was stopped through a court order, and none of the actors in this case can take blame for that state of affairs. It cannot therefore be held that the impeachment of Sonko extinguished the nomination of Onkananu. Having reached the conclusion that the process of appointing Onkananu did not violate the Constitution, it follows that the Speaker, who was then acting as governor, was allowed by law to do anything that would bring that process to fruition. In that regard, we are guided by the provisions of Article 259, sub-Article 3, A and B, which stipulates as follows, and I'll quote that section: every provision of this Constitution shall be construed according to the doctrine of interpretation that the law is always speaking, and therefore, among other things, a function or power conferred by this Constitution on an office may be performed or exercised as occasion requires by the person holding the office. Any reference to this Constitution to a state or other public office or officer or a person holding such an office includes reference to the person acting in or otherwise performing the functions of the office at that particular time. From the above analysis, we find that although the Speaker of the County Assembly, while acting as a governor under Article 182, Subarticle 5 of the Constitution, has no power to appoint a deputy governor, the peculiar circumstances of this case entitle the Speaker of Nairobi City County Assembly to complete the ongoing process of appointment of Hon Kananu as deputy governor. The process had been stopped by the court in the Peter Agoro case, and it is the same court which vacated the conservatory orders, hence allowing the process to proceed to its legitimate and logical conclusion. Had Hon Kananu not been approved by the county assembly, the gubernatorial by-election would then have been held. There were other issues which we considered, starting with the argument by some of the parties that the gubernatorial election, having not been held within 60 days from the date of the impeachment of Hon Sonko by the Senate, no election can now be held as it had been overtaken by events. There was a contrary position taken by the IEBC to the effect that a conservatory order only freezes time and cannot be equated to expansion of constitutional timelines. Interestingly, all the parties relied on the same case, which was the case of George Michael Wanjohi, to advance their competing positions. In view of our findings herein above, this issue no longer requires our extensive analysis. Nevertheless, our brief answer to the question is found in the George Michael case, where the Supreme Court held, under quote, consequently, any statutory process or act done will traverse the provisions of the Constitution. This court will not hesitate to declare them void. Hence, a stay order will not be tantamount to stopping a constitutional process. I'll end the quote there. We therefore agree with the IEBC's position that a court's order staying the occurrence of a constitutional event does not amount to a breach of the constitutional timelines. We cannot imagine a situation where an event ordained by the Constitution will not occur simply because it has been postponed. Another issue was the request by the 7th and 8th interested parties for this court to expunge any reference to them in Hon Sonko's pleadings. This request is indeed available under Order 2, Rule 15, and Order 19, Rule 6 of the Civil Procedure Rules. We have in this judgment already made our determination regarding the veracity of Hon Sonko's pleadings and averments over this issue. Our view is that the averments and pleadings of Hon Sonko conveyed his case as he perceived it. The power to strike out pleadings and averments should be exercised cautiously, lest the right to access justice is interfered with. Our determination that Hon Sonko's pleadings in relation to the 7th and 8th interested parties are unbelievable is sufficient protection of their right to correction and deletion of untrue or misleading information. Any infringement of the right to privacy can be pursued through other processes or litigation. Regarding the issue as to whether the IEBC violated the law by publishing gazette notice calling for by-election for the position of governor of Nairobi City County, we do find that the action of the IEBC are a direct consequence of the letter from the Speaker of the County Assembly informing the Commission of the vacancies in the offices of the Governor and Deputy Governor. We observe that as at the time of the impeachment of the Governor, the process of appointment of the nominated deputy had been stayed by a court, but was soon thereafter reactivated. It is therefore our finding that the IEBC cannot be faulted for calling for the by-election. As we have already stated in this judgment, a by-election would have indeed been conducted if Hon Kananu had not been approved by the County Assembly. Before we leave this issue, we find that an order of certiorari quashing the gazette notice is no longer necessary in view of our findings. So, having regards to the above analysis, it is our finding that the nomination, vetting, approval, and swearing in of Hon Kananu as the Deputy Governor was constitutional and complied with the applicable laws. Consequently, we find that all the petitions challenging her ascendancy to the position of Deputy Governor are without merit and are hereby dismissed. Conversely, our above holding is sufficient to take care of the prayers in Honkananu's cross petition and that of the fourth petitioner, Josephat Kariuki. On costs, the general rule as provided under Section 27 of the Civil Procedure Act is that costs ordinarily follow the event unless for good reason the court orders otherwise. The consolidated petitions are in respect of a novel issue concerning the governance of county governments. The appropriate order in the circumstances is to direct each party to bear their own costs. Before we sign off, we take this opportunity to appreciate the parties and their advocates for their industry and research in this matter. These are the orders of the court.
Most obliged, my lady. Most obliged, my lady. On behalf of the Fascist Party, my lady and the Lord, Mrs. Harrison, to request for the certified copies of the proceedings and the judgment.
The third interested party categories joins in that request.
General Chief, also on behalf of the 10th interested party, Short Muguko also wishes to apply for the proceedings and also a copy of the judgment.
Also, the 10th petitioner wishes to apply for proceedings and a copy of the judgment.
My Lord, the 8th and 9th petitioner also wish to ask for a copy of the proceedings and the judgment.
Your Lordship, also for the third petitioner, we wish to request for copies of the same.
So, copies of certified proceedings and judgment to be supplied as prayed to all the parties who shall ask for them upon payment of the requisite fee. There was somebody talking? Okay.
My Lord, given that copies of judgment are not immediately available, and given that the court indicated that the same will be available at the earliest of Monday, my Lord, parties may be inclined to challenge the decision of the court, yet they may not be. They may not have.
Mr. Nyamu, sorry for cutting you short. This judgment will be available online in the next 30 minutes. We are not adding anything, and as soon as we pen off, you can call our court assistants for copies. They can photocopy and give you a raw document where you can. It has been signed. We do not wish to. The judgment is okay. What will have problems will be the proceedings. Yeah. It will be sent online shortly. After we leave.
I'm guided, man.
Okay. So we go to 425. Can we take the quorum in this judgment? We have on mic Sonko.
Mr. Nyamu, you are addressing the court.
Yes, my lord, in this matter, my name is Wilfred Nyamu, and I do appear together with my learned friends, Mr. Harrison Nyanjui, Mr. Evans Odieki, Dr. Hamino, Professor Mikai Akesh, and Mr. Alphonse Mutina for the first petition.
Clerk, Nairobi City County.
Yes, my lord and my lady. Yes. My name is Osundwa. I appear together with Ms. Shaunda.
The Speaker of the Nairobi City County.
My lord,
for the Speaker of the City County Assembly, the second respondent.
Nairobi City County Assembly. The first one was the clerk. Third respondent.
Your Lordship, my lady. My name is Ashia, for the third respondent.
Fourth respondent, Senate, Speaker of the Senate of Clerk, Speaker. Yes, Ms. Thanji.
Yes.
The AG.
My Lord, Ms. Ndong, present.
IBC.
My Lord, in this one, I appear, Mukele, my Lord, Mukele.
Yes.
I appear together with Mr. Mahmoud Jabane for the IBC, my Lord.
Assumption of the office of the County Governor Committee.
May it please do my lady and my lord. My name is Okach. I do hold brief for Mr. Ndwiga, who appears for the 9th respondent.
10th respondent.
On my part, my lady, my lord, my name is Okach. I do appear for the 10th respondent in the matter.
Have we left anybody?
Those were the appearances and have been the appearance. So everyone is accounted for.
Okay, I will use the same procedure. So this is the judgment of the court. We have introduced the subject and all the parties. There were 2 petitions and the same were consolidated. We have explained the first petitioner's case. The 2 petitions are more or less the same, but we have explained what they contain and their respective prayers. We have given a long analysis of the petitions. Then we have come to the respective submissions of the first petitioner and the second petitioner, the issues they raised. The first petitioner raised the issue whether the court has powers to review decisions of the county assemblies and the Senate, and whether such review violates the separation of powers. The submissions to that effect. Second issue, whether the Senate met the constitutional threshold for impeachment. We have explained, this is the petitioner's case. So see whether the Nairobi City County Assembly and the Senate violated the first petitioner's right to fair administrative action. We have given the case by the first petitioner, whether the requirement for public participation was complied with, whether the removal of the first petitioner from office was conducted in accordance with the Constitution and the law. That is part of and the authorities cited, we have also explained and summarized. The second petitioner's submissions, more or less the same but with a different angle. We have explained that. The respondent's case, the first respondent, the clerk, Edward Obori, Gichana, the governments, and the submissions have been considered. The first respondent submissions, we have considered them. Then we have the second respondents on Benson Mutura, Speaker of the County Assembly. There was a long affidavit and annexures. We considered them and the submissions equally. According to him, the issues raised is whether the impeachment motion was validly lodged, whether there was non-compliance with any court order, the quorum and voting system, and the remedies. So the third respondents mainly filed submissions, and the issues he raises is whether the first petitioner was lawfully and or regularly impeached, whether the petitioners have made a case for the grant of the prayer sought. The fourth, fifth, and sixth respondents' case, we have explained it, and their submissions. The seventh respondent's case, the AG opposed the petitions through grounds of opposition. We have seen those ones plus the submissions. The eighth respondent's case filed a replying affidavit sworn by Michael Goa on 16th April in response to the petitions. We have analyzed that one plus the brief submissions. The 10th respondent's case, we have briefly analyzed because he had two caps, one as the speaker and another one as the acting governor. So we have one paragraph for him as the acting governor. So this is the analysis. I will read where necessary. We have carefully considered the pleadings, the written and oral submissions, and the authorities of the parties. We have also considered all the issues as framed by the parties. In our view, we are required to first determine whether we have jurisdiction to determine the petitions. If we establish that we have jurisdiction, the key issues that we are required to determine are whether the first petitioner was accorded fair administrative action during the impeachment proceedings and whether the impeachment met the constitutional threshold. So the first issue of jurisdiction, the Speaker of the County Assembly is of the view that impeachment of governors is the preserve of the Senate and county assemblies. Maintained that the impeachment process, having complied with the constitutional and constitutional requirements, this court is barred by the doctrine of separation of powers from entertaining the petitions. The Attorney General also was of the same view. The petitioners took a contrary view to that of the respondents. The petitioners asserted that the conduct of the County Assembly was so perverse that it amounts to the violation of the Constitution, thereby requiring intervention of these courts. We have explained all that in discussing the doctrine of the separation of powers. We have gone to the Supreme Court in the case of the matter of the Interim Independent Electoral Commission Advisory Opinion number 2 of 2011, and we have captured one of the paragraphs there. The Court of Appeal also took a similar issue in Momomatemo, the case of Doctors for Life. So, guided by the above cited decisions, we find that the doctrine of separation of powers does not inhibit this court's constitutional power to examine and interrogate the impeachment proceedings of the County Assembly and the Senate, where a party alleges that there was violation of the Constitution and the law. This finding leads us to the inevitable conclusion that this court has the jurisdiction to hear and determine the petitions. So the second issue has several subtitles. So the first one is fair administrative action. In addressing the issue as to whether the first petitioner was accorded fair administrative action during the impeachment proceedings, this court is called upon to consider whether there was a proper notice of motion for impeachment before the County Assembly, whether the first petitioner was properly served with the said motion, whether there was quorum in the County Assembly during the debate and the voting on the motion, whether there was fair hearing both at the County Assembly and the Senate. The first petitioner contended that the action of the County Assembly to receive the motion, debate and pass a resolution impeaching him as the governor contravened the Constitution, particularly Articles 1, 10, 48, 50, 174, 182, 196, and 200. It was submitted that the motion dated 25th November 2020 was not verified or accompanied by sworn affidavits of the MCAs supporting it, and that this violated the Constitution and the County Assembly Standing Order number 67. And also there was mention of Standing Order number 72. Another aspect of the above issue is the first petitioner's contention that at the time the motion mover Hon Michael Ogada Okumu presented his motion, there was already a pending motion by Hon Peter Imwatok that had been stayed by the court in the Employment and Labor Relations Court case number 35 of 2020. It was also submitted that the motion was debated on 3rd December before the expiry of the 7 days period provided by County Assembly Standing Order 67 form. The respondents of the contrary view. It is submitted that an impeachment motion is a special motion that has to be disposed by the Speaker within seven days of receipt from a member and deliberated upon within 3 days following approval by the Speaker. Position that a special motion lapses if there is failure to comply with the set timelines. According to the respondents, the motion by Hon Imwatok had lapsed by the time the second motion was lodged. Standing Order 67 of the County Assembly provides for the procedure for the presentation of a motion to impeach the governor. The record shows that the motion by Hon Michael Ogada was delivered to the clerk on 25th November 2020 and received by the Speaker the following day. Standing Order 67 stipulates as follows. We have reproduced, it's not a long section. Upon the expiry of 7 days, after notice given, the motion shall be placed on the order paper and shall be disposed of within 3 days, provided that if the County Assembly is not then sitting, the Speaker shall summon the Assembly to meet on and cause the motion to be considered at that meeting after notice has been given. Standing Order 67 is titled Procedure for Removal of Governor by Impeachment. This is the law that should guide the County Assembly when deliberating on an impeachment motion. The respondents have correctly pointed out that under Standing Order 49, an impeachment motion is a special motion which has to be disposed of by the Speaker within 7 days of notice from a member. We nevertheless observe that Standing Order 49-2 permits a lesser or longer period as specified by the Constitution, any written law, or standing orders. Standing Order number 67-4 provides that an impeachment motion shall only be placed on the order paper upon expiry of 7 days, and that is the provision to be followed in the impeachment of a governor. Article 259 of the Constitution, in which the Constitution should be interpreted, of relevance to us are subtitles 5 and 6. We have reproduced those two subtitles of Article 259. Applying Article 259.6 to Standing Order 67.4, we find that the notice of 7 days required therein includes Sundays and public holidays. From the record, the motion by Hon Ogada was presented to the clerk on 25th November 2020 and approved by the Speaker on 26th November 2020. Under Order 67.3, upon approval of the motion by the Speaker, the mover shall give a 7 days notice calling for the impeachment of the governor. By virtue of Article 259.5a, 26 November 2020 is excluded from the 7 days period. However, the 3rd of December 2020 is included. We find, therefore, that the 7 days period requirement was complied with. Standing Order 67.1 requires that the motion be verified and signed by at least 1/3 of the MCAs to confirm that the particulars of the allegations contained in the motion are true to their own knowledge. The evidence on record shows that the notice of motion delivered to the office of the clerk was